kind of attitude back. But if you treat them openly and you want to deal fairly, I think as a general rule, that's what you'll find from the insurers.
There was one question here from this gentleman who stood up earlier.
The question, I think, is on the eve of trial, new information comes to light, medical evidence to indicate that the... Right, sometime before trial, at least the case is well underway into litigation, and information comes to light that indicates, at least to the plaintiff's solicitor, the case is worth a lot more than what you were initially talking about, and whether or not you should disclose this to the other side. Well, I think that the answer is a simple yes. I don't think it matters at what stage. Usually by that time you're dealing with defense counsel and not an adjuster in any event, although the adjuster often is still sort of in the background. But I think the answer is yes. And from the defense side, we surely want to know that information as early as we can. Because even at that stage, we'll adjust the reserve if we feel your information is legitimate.
Michael, thank you very, very much for joining us today.
Thank you.
I think it's time now for a coffee break. Coverage question for a few minutes, because there's been quite a bit of interest shown on that topic, and notwithstanding Mark Lerner's enthusiastic, I think he may have rushed on some points because I had put some constraints on his time. But I'd like to go back to the topic and invite some additional comments from Mr. Lerner. We've also got Mr. Tom Montgomery now, who's joined us. I'd like to emphasize, Mark, please, the distinction between uninsured and underinsured. What is mandatory under the Insurance Act now? What is a contractual option to purchase, please?
The Insurance Act stipulates that uninsurance forms part of the policy. That the uninsurance is something that you get in any event through Section 231 of the Insurance Act. You all have uninsurance coverage on your own motor vehicle policies. So not to worry as far as that is concerned. But the big distinction between underinsurance and uninsurance is that underinsurance is optional. It is contractual, and you buy it from your agent. It's cheap. It costs you $5 or $10 for the additional premium depending on your own Section A limits, but it is something that you go out into the marketplace and purchase, so that there are still people wandering around this city who do not have SCF 42 coverage, and that's why I indicated to you at the end of my remarks that if you had to make the choice between having Section A third-party liability and SCF 42, of course you don't have to make the choice. SCF 42 is what you need, and you should have it on all of your policies. And also that raises the other issue that I touched on briefly, is that if you have a client who doesn't have it, the reason he may not have it is because his agent or broker did not suggest it to him or add it automatically, which I suggest about 80 to 90% of all agents are doing in any event now, based on the recommendations that have been made by the Agents and Brokers Association. So if you have one of these cases that slipped between the floorboards as far as the agent is concerned, and he did not add the SCF 42 coverage, you may have an action against the agent, or your client may have an action against the agent.
Is that distinction clear enough, or are there any questions on that point? Please don't hesitate.
Mark, can you get SCF 42 coverage in excess of the third-party liability? You seem to say that you can.
Can or cannot?
Can you get SCF 42 coverage in excess of the third-party liability?
No.
So, you have a choice of getting third-party or getting SCF 42 because you can't get the one without.
Oh, no, I say that facetiously. I mean, if you were able to make the choice, and you cannot make the choice, I don't want to mislead anybody, But if somebody came to you and said, what would you rather have, third-party liability limits or SCF 42, I mean, the joke that I'm trying to make, obviously hysterical. You know, he's in my office. He practices about 15 feet away from my desk. I don't need this aggravation.
So
The point that I'm trying to make is the SCF 42 is crucial, and that you should all have it.
All right, Norman?
Comment on the limitation period, SEF coverage as opposed to the other coverage under section 231.
Well, maybe,
My understanding is, I understand your notion, I've read the decision by Justice Gray. When you have an SEF coverage, the mass practice, you do not, in 1 year period, issue your writ against the insurer.
As a matter of practice, that's what I do, and I believe everybody in my office does. Mr. Justice Gray would say you don't have to do that, because you only issue your writ against the SCF 42 carrier when the cause of action arises, and he says it doesn't arise until there is a breach of the contract when the underinsurer carrier, that's the SCF 42 carrier, denies payment or doesn't pay or there's a shortfall. As a matter of practice, though, save yourself the potential grief and issue the writ within the 1 year until there's a Court of Appeal decision telling you otherwise. Yes.
Now, under section 231 coverage, the limitation period is 2 years as an ordinary,
Highway Traffic Act limitation period, yes. It's 2 years. All of the cases, with the exception of Schmidt and Janus, would indicate that it is a 2-year limitation period. Once again, as a matter of practice, I don't want to have those kinds of problems, and I issue the limitation period within 1 year.
do you, as a matter of practice, when you do not have an SEF coverage, do you, as a matter of practice, issue your writ, when you issue your writ, within your 2-year period, against your defendant, you're acting sort of the plaintiff, you sue the defendant, do you, in your practice, add the plaintiff's insurance company in case there is underinsured coverage? In the action, let's say that you're acting for the plaintiff, you go to the court, you get a judgment for $110,000, the defendant has $100,000, there's a $10,000 shortfall. Have you sue your own insurance company at the same time you sue the defendant?
There's two answers to that. In some cases, the cases that are about,
Mark, you have to restate the question just
I beg your
briefly, if you
pardon.
don't mind.
the question as I understand it is, do you as a rule start your action against the underinsurer?
That's your own insurance company. That's the plaintiff's own
Yes.
insurance company.
Is that a fair statement of your question? Two answers. One is that up until Pelche and Guitar, yes, the action was started as a matter of course, and in some cases, depending on the severity of the injury and whether you had a reasonable expectation that there was going to be a shortfall, that action continued on as a companion action with the main tort action. Since Pelche and Guitar, our practice has changed somewhat, and it's only in the case of devastating injuries do we start those actions. It's I guess the best answer is how much can you afford to be wrong?
My understanding is that under section 231, let's forget about the SEF coverage. That's contractual 1-year limitation period. An ordinary action, plaintiff versus defendant. Plaintiff wins $110,000. Defendant has $100,000 covered. My understanding is that under section 231, you then call your insurance company. Let's forget the fact that, to put brackets around the fact that we have all along said, hey, by the way, there might be an excess problem here, so we're putting you on notice. Let's say you don't do that.
Well, you're going to find out well in advance of that because, just so that nobody is misled, you're not going to have a $100,000 situation because the minimum compulsory limits are $200,000. Secondly, you're going to know well in advance because there's got to be somebody defending that action. And if there's nobody defending that action, then your rights will accrue when you have a judgment. The wrinkle comes in with the Schmidt and Janisch case, which says that which goes contrary to Pelche and Guitar as to when the limitation period runs. Tom, what's been your experience with with Schmidt and Janisch and when the limitation period starts to run with the uninsured driver?
Well, I share Mark's views in what he has said. I think with great respect to Justice Carruthers that his decision is in error, bearing in mind what the Court of Appeal has said about not continuing the actions together. As you've pointed out, Norm, that you ought not to have, I think is the way they have said that there's no right to bring the action against the company directly in those circumstances. I favor the Pelche decision, Mr. Justice Gray's decision, and I think that ultimately will be the one that will be upheld in the Court of Appeal. But as Mark has said, the practice is to be on the safe side, issue your writ within the year.
That's 1 year from the date of the accident.
Yes.
What's the limitation in an unknown motorist situation where you're going against your own insurance company?
It's the same as uninsurance. Unknown and unidentified is exactly the same.
1 year?
Well, no, it'll be 2 years. Remember, just because it's unidentified, you can lump unidentified, unknown, uninsured all in the same basket. You've still got a 2-year limitation period under the Highway Traffic Act.
I think the confusion arises because SEF number 42, which is entitled Underinsured Motorist Endorsement, has a specific limitation period, and this is a contractual limitation period, as is being pointed out, and it reads, every action against the insurer for recovery under this endorsement shall be commenced within 1 year from the date when the cause of action arose. So the question is, when did the cause of action arise? Does it arise on the date of the accident, or as Mr. Justice Gray says, later? I think the safe position to take until the Court of Appeal has ruled on this issue is to issue your writ within the 1 year limitation period. 1 year from the date of the accident.
The question is for the people upstairs whether what happened in Waterloo and Zurich, did the plaintiff add the insurer or did the insurer take it upon their own to have themselves added to the action? And the answer is the insurer took the position to have themselves added. I think the decision stands for the proposition that regardless of who adds them, whether it's the plaintiff or whether the insurer takes it upon themselves, the Court of Appeal says the insurer can't be there, the theory being that it places the insurer in a position of conflict with its own insured.
The case that Mark and I had in front of Mr. Justice Rutherford was a case where the plaintiff had chosen to add the underinsurer, so that was a plaintiff's option, and Mr. Justice Rutherford interpreted Zurich and Waterloo as not giving the plaintiff that right. So it's an objective test. It's not up to the plaintiff to choose. Now that case is also under appeal.
That case is called Grant versus Hess.
I'm glad you remembered it. I just could not remember the name.
And it should be coming on in the Court of Appeal in September or October of this year.
Well, shall we go on with the rest of the program, because this is an area that I'm sure we can take all day with. Our next speaker, thank you, Mark, for the return engagement. Our next speaker is Mr. Peter Daley, who's been involved in this very interesting technical area of accident benefits, and I've asked him to update everyone here on that topic.
Thank you, Barry. Before I begin with my topic, I'd like to refer you to two excellent articles that have been written in the past on this. They're both written by Ted Racklin, QC, The first one was written in 1973, and it's at the 7 Law Society Gazette, page 282. The title of the article is No-Fault Insurance, What Should the Practitioner Do? And a follow-up article on that, following the amendments to the Insurance Act in 1978, again by Mr. Racklin, and again in the Law Society Gazette, 1979, volume 13, was entitled Accident Benefits Revisited. I would highly recommend both those articles to your reading, as they are very comprehensive in the way they deal with no-fault legislation, and in particular the last article, the the 1978 article, which reviews the effects of the amendments in 1978. With regard to the 1978 amendments, I would draw to your attention the fact that prior to 1978, the payment of no-fault benefits was contingent upon the test of disability. The prior wording with respect to Part 2 of Schedule C, or Schedule E as it used to be, was death and total disability. Since 1978, the wording of that, and apparently the philosophy of the legislation, has changed to death and loss of income payments. Thus, the apparent test following the 1978 amendments was that the insured claimant had to demonstrate a loss of income. And generally that appeared to be the accepted position, and that was generally the view of the insurance industry, and in particular most defense counsel. Part 1 of my paper deals with this issue, and by sort of jumping to the end and the conclusion that's reached from the cases I'll review with you, that impression, namely that a real loss of income had to be demonstrated, appears to be wrong, or at least in the view of the recent cases that have been coming out of our courts. Dealing with that issue, it appears that it's centered primarily around the question of whether the claimant is employed within the meaning of Schedule C, or whether he's deemed to be employed within the meaning of the schedule. Now, it's difficult when you read the cases to extract any succinct or precise statement of the law as it presently is, other than to say that regardless of whether a person has a real demonstrable loss of income, the courts will appear, so long as he satisfies the other tests with respect to disability, it appears the court will award the no-fault benefits. Now, I hope to move through the material fairly quickly. There's a lot of it. The first case which I refer to in the materials of some importance is the Kloppenberg versus Pitts decision. That's a decision of Mr. Justice Maloney, which was affirmed in the Court of Appeal. The simple facts of the case are that the plaintiff, who was a student, was involved in a motor vehicle accident while employed in a summer job. He sustained very serious injuries and resulted in being a paraplegic. It was an accepted fact in the evidence that he had intended on returning to work in the fall of that year, and in view of that, the insurer's position was that if this individual is entitled to no-fault benefits, he's only entitled to those benefits during the period where he would have otherwise been employed, namely the summer. Mr. Justice Maloney looked at what is described in my material as the deeming section, where you look if the person doesn't have a contract of employment. He takes the words in the deeming section of Schedule C, Part 2, and he uses those words as a basis or form of definition of the word employed as it's used in the opening words of Part 2. In the result, he held that, given the fact that the deeming section was so generous or so broad in that it gave someone who might not even had an actual loss of income the benefits of payment of accident benefits, he should not, in the facts of this case, deny this young man benefits throughout the term of his disability, regardless of the fact that beyond, say, the Labor Day weekend, he technically wasn't losing any income. The Court of Appeal, as I say, affirmed the decision. That issue was not dealt with in great detail, but it was left undisturbed. leave was applied for to go to the Supreme Court of Canada, and I understand it was denied. So that case stands for the positions I've stated it, as far as I know. Again, when you look at the caption or the phraseology used in Schedule C, it would appear on a simple reading that you have to demonstrate a loss of income in order to be entitled. Again, Justice Maloney in the case seems to ignore that fact and treats the individual as entitled simply on demonstrating that he was employed or deemed to be employed and suffered the requisite disability. Two further cases on this issue, both which are related factually, are the decision of Bragagnolo and McIver and Todd and Pitts. Both of those cases are cited in my material. Both of them have a common factual base in that the plaintiff claimant who was pursuing his no-fault insurer was involved in a job retraining program through the auspices of a provincial or federal government agency such as the Unemployment Insurance Commission at the time the accident occurred. Therefore, the issue was being enrolled in a job retraining program, does that constitute employment, or is he deemed to be employed at the time the accident occurred, and thus is he entitled to any benefits? Justice Osborne in the Bragagnolo case, which followed the trial decision in Todd, held that the person, while enrolled in this occupational training program, was receiving an allowance, part of which could be described as a wage. He therefore held that the person was deemed to be employed, although in the common sense and the common understanding he would not be usually viewed as being employed. He concluded for other reasons that although he was deemed to be employed, the benefits were not payable to him, or not available to him, I should say, due to policy violations on the part of the claimant. The Todd and Pitts decision was a decision of Mr. Justice Robbins, as he then was, as I say, on very similar facts. Again, it was an occupational training program. The fellow was not, in a common sense, employed in a traditional job. The Court of Appeal, well, as I said, Robbins made a ruling very similar to that Mr. Justice Osborne did. And in fact, Osborne J. followed Robbins J.'s lead on this. However, the Court of Appeal, when it got a hold of the Todd's decision, held that the allowance paid to Mr. Todd was a living allowance alone and didn't really constitute wages or profit within the meaning of the words used in the deeming section. And because it was not earned or obtained in the pursuit of a trade, Mr. Justice Jessup held that he was not employed and thus disentitled to any benefits. The next case of importance, which I would direct your attention to, is that of Lamb and State Farm. That's a decision of Madam Justice Boland, and when you examine the reasons of that case, it seems apparent that the Kloppenberg case, which predated it, was not referred to the court, or at least it's not mentioned in the reasons. The simple facts of the case were that the plaintiff, Mr. Lamb, was in a position of temporary layoff at the time he had a motor vehicle accident. But at the same time, he also had accepted a position for a new job to commence a month or two following the accident date. The insurer's position in the case was that Mr. Lamb was not employed or deemed to be employed and therefore disentitled to any benefits, or alternatively that if he's found to be employed, that no payment should be given to him during the period he's in a state of layoff because he's not suffering any wage loss. Madam Justice Boland found that Mr. Lamb was employed or qualified for the benefits, both from the fact that he was simply a temporary laid-off employee and he did have a valid enforceable contract of employment, which would likely result in him returning to that job at some point. And also on the alternative base, she found that because he had an enforceable contract with a new employer with whom he had not yet commenced work, he was also employed. So there was no issue as to whether he was employed or not employed as far as the judge was concerned. However, contrary to the results in the Kloppenberg case, Her Ladyship denied Mr. Lamb any benefits for the period wherein his employer would have had him in a layoff position. Her view being that there was no real loss of income sustained during the layoff, therefore no entitlement to benefits. And as I say, that appears to run counter to the reasons of Mr. Justice Maloney in the Kloppenburg case. The next case of interest is that of Peacock and Gore Mutual, a decision of Mr. Justice Traynor. Again, the citation for that case is in the material as well. Factually, this case involved a lady who had been employed for 6 out of the preceding 12 months before the accident. At the date of the accident, she was a housewife. The insurer took the position that as she wasn't suffering any loss of income, whether she's deemed to be employed or not, they don't have to pay her any benefits. Mr. Justice Traynor reviewed the earlier decisions and held that although there was no loss of income demonstrable on the part of the claimant, it was unnecessary for her to demonstrate that, and that proof of real or actual loss of income was unnecessary. He held, in reviewing an earlier decision, a decision of Judge Carisco in Thunder Bay called Bay versus Cooperators, which is also cited there. He distinguishes that case and virtually overrules the reasoning of that judge in holding that if you were not to treat the deeming section as providing payment where there's no loss of income, the whole deeming section would be redundant and meaningless. And it would also unduly narrow the whole field of people entitled to benefits. The only case that I'm aware of that's gone to the Court of Appeal on this issue is an unreported decision called Jovanovic versus Commercial Union. It was tried before the Honorable Judge Zalov in Essex County in Windsor and was affirmed by Mr. Justice Tarnopolsky in the Court of Appeal. The Court of Appeal reasons are very brief and really do not deal with the case law, but simply affirm the reasons and the mode of calculation used by the trial judge in allowing the accident benefits. Factually, the case involved a fellow who was an employee of Chrysler. He was in a state of layoff at the time the accident occurred, and the insurer took the position that he would not be entitled to benefits because he was not losing income and not technically employed actively at the time the accident occurred. The trial judge held that he had an enforceable contract of employment primarily through the fact that he was party to his union's collective agreement, and the fact that he was on a temporary layoff, the prospect being that he would have returned to work within a number of months following the accident. Also, the case confirms the prior position, contrary to the Lamb case, that although there's no real loss of income throughout the layoff, the court did not interfere with the trial judge's award of benefits throughout the layoff period, where in fact no loss was really being suffered. The last case under this heading in my paper I'd refer you to is the decision of Thompson and Zurich, which was released in April of this year. It's a decision of Mr. Justice Pinnell. And without going through the facts, it's very similar factually to the Kloppenburg case, and I'd highly recommend you read it as a very good summary of all the cases up until this point, including Kloppenburg and the other authorities. The case is interesting from the standpoint that the no-fault insurer, having denied the benefits to this victim or claimant, the facts were such that the trial judge awarded aggravated damages to him for the conduct of the insurer in denying the claim. Now, turning to the second part of my paper, you'll note deals with the application for accident benefits in respect of loss of income, and also the effect of the release contained in Section 239 of the Insurance Act. Having said what I've said so far, and having pointed out to you the various cases dealing with the entitlement to benefits, it seems pretty clear that the courts are being very liberal in the awarding of accident benefits. And I think as plaintiff's counsel, that should be kept in mind in all your cases to ensure that you get the benefits that your client is entitled to. And in particular, I would highly recommend that unless you're totally satisfied there's no entitlement, application should be made. With respect to the application and the notice requirements, I'd simply refer you to subsection 3 of Schedule C, where all the times are prescribed. The only warning I guess I would give is that the limitation with respect to suing for benefits is considered in the decision of Morgan and Dominion Insurance, which is referred to in the material and cited there, and stands for the proposition that an action with respect to those benefits should be commenced within at least 1 year from when the disability commences, because that is the liability of the insurer. In other words, if you commence the action 6 months post the commencement of disability, the insurer's liability only extends back 1 year from the date upon which the writ is issued. So your client may lose out for some of the benefits he would have otherwise received. Now, Section 239, subsection 2, is the one that all defense counsel and insurers will raise with respect to seeking credit or a release to the extent of benefits that your client received or should have received upon proper application. I'll comment in a moment about this issue of entitlement and availability. When you examine the cases that I've cited, in particular the Bragnolo decision, which I referred to earlier, you will see how that distinction is drawn between entitlement and availability and the effect those terms and the way they're viewed has on the release provision. The most recent case of importance dealing with the effect of the release in Section 239, subsection 2, is the Court of Appeal decision in Stante and Boudreau. And that case appears to stand for the proposition that where an application is submitted by a no-fault claimant and the application is submitted presumably in a proper and complete form and in a timely fashion, if the application is rejected, the claimant does not have to pursue his own no-fault insurer in order to protect himself with respect to the release provision or the operation of that release provision. Mr. Justice Zuber for the Court of Appeal simply said that so long as the application is made and availability is disputed, there's no need for the claimant to pursue two actions, namely one against the tortfeasor and one against his no-fault insurer, because that would result in fragmentation of the plaintiff's claim, and it wasn't contemplated by the legislation that he would have to do that. Now, as I said, I would refer you to that Bragnolo case for a review by Mr. Justice Osborne of the Stante and Boudreau decision and how it operates with respect to the concepts of entitlement and availability. In that case, going back to the facts for a moment, as you recall, this is the decision where someone was involved in an occupational training program. Justice Osborne held that given the fact that this fellow was insured and that he qualified as being employed within the deeming provisions, he was, in the words of Section 239, entitled to the benefits, but because he had fallen into breach of one of the conditions in his insurance policy, those benefits were not, quote, available, unquote, to him, and thus no credit or release was available in favor of the tortfeasor's insurer. And again, that decision is gives a fairly good explanation as to the operation of the release section. Keeping all that in mind, the next issue is when to sue your no-fault insurer, even if the application is rejected. The answers are fairly basic, the first being quite obvious, I would think. If you feel you have a good cause against the insurer for no faults, and obviously if your client is in need of the funds and you anticipate a prolonged or a lengthy tort action, apply for the benefits. There's no question. Secondly, if you anticipate there's going to be some form of split in liability in the tort action, the result of which will preclude your client from recovering all the lost wages he has suffered, again, apply, pursue them, and if the application is denied, pursue the insurer in an action. And lastly, if you have a major claim and you anticipate that there's going to be a limits problem, or you know there's a limits problem on the part of the third party or the defendant's insurer, and you know your client doesn't have the benefit of an SEF 42 endorsement, pursue them, because your client may be out of pocket all the benefits he would have otherwise received had he pursued his own insurer. With respect to proof of the release as referred to in 239, I'd simply refer you to the case of King and Ward, which is cited and expanded upon in the material. That case details the mode of proving the release on the part of the defendant's insurer and how it's dealt with at trial in the absence of the jury and following the assessment of damages. And I'd just simply refer you to the material for that. It's important in acting for a plaintiff where you've got a substantial no-fault claim to keep in mind that if you are approached by the no-fault insurer to accept a lump sum for all benefits owing and that may be owed in the future, that you keep in mind that the tortfeasor's insurer will be seeking credit for those benefits, both the benefits up until the time of the settlement with the no-fault insurer, plus any future benefits that might have been owing to your client. And I would draw your attention to the case of Catapan and Mitchell, which is in the material, and the warning, I guess, that could be drawn from that case, namely that if you are intending to settle with your client's no-fault insurer, and at the same time you have a tort action underway, it would be prudent to attempt to get the third party or tortfeasor's insurer and his counsel to be involved in that settlement and to work out some arrangement with them, because otherwise, if you settle with the settle with your no-fault insurer, proceed to trial, and you've obtained a lump or a fund of money which your client has, the third party or defendant's insurer will most certainly seek a release for the benefits that you've received, plus the benefits that your client would have been entitled to into the future if there's a permanent disability problem. Thus, you may be impairing any judgment your client might get, in that the Catapan case holds that the release available to the defendant's insurer is not simply for the amounts that are paid, but also for any amounts that should have been paid into the future. And thus, to avoid a double recovery, the court will require, in those facts, where there's been a settlement with the no-fault insurer, that your client, the plaintiff, take part of any judgment he gets, put it into court, and pay out to the no-fault insurer sufficient monies to repay him or give him credit for benefits that would have otherwise been paid into the future. That's a little confusing, and I've tried to state it as succinctly as I can in the material, but again, I'd refer you to that Catapan case as the formula set forth there. Now, with respect to the last portion of my paper, I've cited certain miscellaneous areas which have recently developed in the field of no-fault benefits, and I thought I would draw them to your attention as I believe they're important from plaintiff's standpoint. The first one being is the issue of how do you calculate, quote, gross weekly income from employment. You'll note that in Schedule C, Part 2, there's the formulas set forth in determining how much your client is to get based on what other wage continuation plan he has at work and so forth, and what his salary is. The decision that I would draw to your attention is an unreported case of Sue versus Royal Insurance. It came out in March of this year, and it's a decision of Mr. Justice Montgomery. The facts of the case are that there was a young boy, I believe he was about 16 years of age, sustained a very serious injury. At the time the accident occurred, he was employed on a part-time basis, earning about $80 a week. The insurer's position was that gross weekly income from employment for the purposes of Schedule C was $80 a week. The claimant's position was that that was unrepresentative of his real income, in that he worked in the summer months and he worked in the Christmas season, and he had other income which would substantially increase his average weekly income, and thus, given the severity of his claim and the fact there was a long-term disability anticipated, it would greatly increase his entitlement to a larger sum. Mr. Justice Montgomery, reviewing the section, said that gross weekly income from employment was equally consistent with the income in the week immediately preceding the accident, as well as the average income. And he commented that where you've got people with income that fluctuates up and down, it would be grossly unfair to have their benefits determined or premised on the income they were earning in the week immediately preceding the accident, when it may happen to be a low week compared with what they earned over the 12 months preceding the accident. And he held that the average income, as opposed to simply the income in the week preceding, would be the basis upon which the formula would be calculated. There's been some concern that that decision will expand the meaning of the exposure, or the amount the insurers will have to pay, but it cuts both ways, in that if the insurer is faced with a claim where someone has a very large income the week before the accident, which is unrepresentative, again, this averaging would result in a more equitable formula for payment. The next issue, which has been litigated, is the issue of where someone has been getting benefits and he has returned to work for a period in excess of 30 days. As you are aware, there's the provision since the 1978 amendments allowing a claimant to return to work for a period and not thereafter be disentitled from any further benefits. I've cited in the material a county court decision from the county of Middlesex, Judge Flynn, Clark and State Farm. In that case, the plaintiff had returned to work for a period substantially in excess of 30 days and had pursued further benefits, the insurer's position simply being that he had returned to work beyond the 30 days, therefore he was disentitled. The judge, rightly or wrongly, I have some doubts about the correctness of the decision, held that the 30 days is simply a guideline, and that so long as the disability the fellow is complaining of at the time he ceases work the second time relates back to the accident and he satisfies the disability test in the policy and in Schedule C, there's no reason that he should be denied the benefits. Now, the judge appears to be reverting to the philosophy in the decision of Fodden and Cooperators, which is also cited there. And it should be noted that that case predated the 1978 amendments. And in that case, the trial judge held that a return to work where the requisite level of disability was total disability should not be used to penalize the claimant by cutting off the benefits when thereafter they end up in a disabled position again. But again, since that case, the wording of the sections changed, and as well this 30-day rule, as I call it, has been inserted. So I'm citing the case to you for what it's worth. I think there's some doubt as to the correctness of it. It was never appealed as far as I know. And the last area I'd like to deal with, which I won't spend any time on, is accident benefits and pedestrians. There had been for some time confusion as to who should be paying a pedestrian no-fault benefits where there is a complex accident scenario with a number of vehicles involved and a pedestrian on a roadway. The Court of Appeal in 1979 in Ezard and Warwick, which is cited there, held that the moving vehicle which pushed a parked vehicle into a pedestrian was the vehicle that was to be looked to for no-fault benefits. Since that case, the Insurance Bureau of Canada has undertaken a rule called a Rule 11A, which I've set out in the material, to which all the signatory companies, signatory insurers, are agreeing to follow, and it was the hope that rule would simplify the job of the plaintiff in determining who he looks to for no-fault benefits given certain fact situations. I don't propose to go through those, and I would simply refer them to you. Subject to any questions you have, that concludes my remarks. Yeah?
It's not clear to me from what you said, it may be clear in the notes, with respect to the 30-day disability. Is it your view that if someone continues working, but is substantially disabled as a result of the accident, and through financial necessity continues working for beyond 30 days, and then subsequently quits working and applies the no-fault benefits, that they're entitled or not entitled?
They would not be entitled. The wording is that the person must be substantially, there must be a substantial inability to perform the essential duties of his occupation or employment.
Yes, well, that's what I'm saying.
Yeah.
If the medical evidence is that person, the doctor's view should quit work, but the person persists in financial necessity or stubbornness or whatever. But assuming that the medical evidence supports the substantial inability, if the person continues working during that first 30 days and then subsequently quits working,
Well,
are they entitled to the no-fault?
the 30-day I'm speaking of is a 30-day period where he has been disabled, received benefits, and then stops receiving, and returns to work.
I understand. I'm asking this other situation.
Oh, okay, you're talking about where there's no time off from work immediately following the accident?
Right.
My understanding is that he would be disentitled on the strict reading of the words. Because the objective evidence, if he's returned to work and the evidence is such that he's been able to, or he's tried to do the job, and the duties of his occupation or employment are examined and he's there, it's likely the court would deny him.
So it's your view that a person has to quit work during that first 30 days,
Well, he has to be,
or lose their, regardless of the medical evidence, or lose their entitlement to claim no-fault?
that's my understanding on the strict reading. I don't know of any case going the other way. Yeah.
I take it that the no-fault insurer who pays has no subrogation rights against the participant.
No. That has been dealt with in the concept of knock for knock, namely that the insurers have agreed not to subrogate as between motor vehicle policies. They will not subrogate against each other for no-fault insurance, benefits paid to their insured. The only case where it may arise is if you have a claim against, for example, it's been suggested anyway, that you may be able to subrogate against the MTC, the Ministry of Transportation Communication, in a situation where an accident arises as a result of a defective road. The insurance available to the MTC is not a motor vehicle policy, and it's been suggested that the no-fault insurer may be entitled to subrogate against that insurer as distinct from a motor vehicle insurer for those benefits. Yes?
The answer may be in the material, but is a claimant's insurer entitled to deny on the basis that the claimant received sick benefits from employment or drew on vacation pay and therefore didn't sustain a loss? And my second question, which is unrelated,
We'll deal one at a time because
Yeah.
you're going to have to repeat it.
The question is the no-fault insurer entitled to deny payments on the basis that the claimant receives, you said sick pay? There's a formula, as you're aware, in Part 2, where they use, it's subsection B, where it's described as a wage or salary continuation plan. Now, it provides a formula where they take the amount he receives from that plan, given his income, and they calculate whether there's an entitlement or not. It would depend on the monies being received and how much.
so the answer to your question is yes.
Generally,
Yes. It's taken into account,
it
yes.
works in the formula and it produces the amount that you're entitled to for actually benefits.
Those are the sick benefits while this person is off work.
Yes.
Say.
Right.
My second question is there a different test to entitlement for the first basic 2 weeks where you get 140, which then may be reduced?
Now, my understanding, that's a mandatory first 2 weeks.
You just get the 2 weeks.
I'm sorry?
It's mandatory, it's automatic. If there's a disability within the meaning, they don't require, they don't question it to the extent they would beyond that period.
Well, the case that I had, coincidentally, the person was off work 2 weeks. Are you saying that the answer to my first question is different for that basic 2 weeks?
He should get the benefits for those 2 weeks.
Whether you've got sick benefits from work or not?
No, they would calculate his entitlement based on the wage continuation plan he had at work in conjunction with his salary and the available benefits. Yes?
Is there any difference between a wage or salary continuation plan and an employer that voluntarily pays full wage while an employee is disabled? In other words, how do I tell that my plaintiff client has a wage or salary continuation plan?
Well,
He is getting 100% of his salary. Can I get no fault benefits?
I don't know the accurate answer, but my belief is that a wage or salary continuation plan would include the gratuitous payments made by your client's employer throughout his disability. I may be wrong, I'm not sure. Yes? Yes?
Contract of employment, so he's entitled to collect the no-fault benefits, the loss of income provisions. And the action is then brought against the tortfeasor and goes to trial and you get judgment. Can you argue that the insurance company of the tortfeasor is not entitled to credit where you do not have special damages for loss of income because the person would have remained off on layoff during the period of time in which the suit was in litigation?
Try to simplify. I think I understand the question to be that you got someone who's on layoff at the time the accident occurred. He gets the no-fault benefits.
He gets them because he's deemed to be employed, he has a contract of employment.
Yes?
You go and sue the tortfeasor, you get your judgment, and the tortfeasor says, under 239, I want that $10,000 you got of no-fault benefits. Can you say no, because I suffered no special damages, no loss of income, in which those no-fault benefits are set off against?
I don't think so. I think the answer is that Section 239 sub 2 is broad enough to include that, and that the the third party, your tortfeasor's insurer, would be entitled to credit for any payments received by your client under Schedule C. Yes. Is that right?
You can see there are a lot of questions still, but I think we better go on because we've got the lunch hour coming up. Thank you, Peter. We appreciate your very, very good presentation.